Hello, my name is Michael Tessera, and I prepared this presentation entitled Pulling a Swifty, GetSwift Litigation. And in this presentation, I'll be seeking to outline the GetSwift litigation commenced by ASIC. And there are three decisions I'll be looking at: the liability decision by Justice Lee, the scheme of arrangement decision by Justice Farrell, and the penalty decision by Justice Lee. I make an admission straight up. I haven't read the whole decision by Justice Lee on liability. It's about 850 pages long, but I think I've extracted the things that people need to know. And I guess the problem with this particular case, it was very bad conduct, and unfortunately, the scheme of arrangement that was approved by the federal court pretty well pulled the rug out from underneath a number of different groups, including ASIC and the class action. And as a result, none of this penalty that was awarded against GetSwift or the directors is going to be paid. And similarly, the class action ended up recovering no money. A bit background about myself: I'm a competition consumer lawyer, and I've been running my own practice, Tessera Legal Consulting, for the last 15 years. I help companies with competition and consumer law matters. I also do consultancy work for both LexisNexis and CCH on competition and consumer law. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the outline to the presentation, I'll start with some background, then look at the first case, the liability judgment. That's the 800-page one. Then a quick look at the GetSwift scheme of arrangement decision, which, even though it is the first decision, it makes sense to look at it second. And then finally, the penalty decision by Justice Lee, which was fairly recent. And I'll finish with some commentary. Now, the background to the case is GetSwift was described as a former market darling listed on the ASX, and it was a new start technology company. And what it was offering was this software as a service on the GetSwift platform, which was basically for the management of last mile delivery services on a global basis. And it started with quite a flourish. It experienced a dramatic ascension in the value of shares, starting at $20 back in December 2016 and rising to over $4 prior to a trading halt, and then a second placement of shares, which raised $75 million from investors. But just as quickly as the company rose, it also collapsed. So 1 year later, on 7 December 2018, the share price dropped to 52 cents, which was a 90% drop from its historic high of $4.30. Now, the ASIC allegations fall into four categories. Firstly, allegations against GetSwift that they breached their continuous disclosure obligations. There were 22 alleged contraventions of Section 674, subsection 2 of the Corporations Act, and 40 contraventions of the Corporations Act and ASIC Act in relation to misleading representations. Also, the executive chairman and chief executive was accused of being knowingly concerned, Bain Hunter. It's an interesting first name, Bain. The third respondent was John McDonald, who was the managing director, who was also accused of being knowingly concerned in GetSwift's breaches. And then Brett Eagle, who was a solicitor, non-executive director, and also the general counsel. So there's a disclaimer at the beginning of Justice Lee's liability decision, and I'll just read it out. It's pretty amusing, I think. This is a long judgment. I'm tempted to say too long, but as will become evident to anyone who has the misfortune of being required to read it, the case advanced by ASIC was vast in scope, involving the need to wade doggedly through a prodigious documentary case and make innumerable findings along the way. Excuse me. After finally emerging from the Dalian maze, one suspects that without detracting from the ultimate regulatory outcome, ASIC's case could have been refined significantly. But alas, this litigious battle was fought on a broad front. So that's a constant theme throughout the various judgments of the size of ASIC's case and whether the case it took was simply too big and too involved, and whether it should have taken a narrower and more targeted case. So the first set of allegations related to GetSwift's ASX announcements, which told the market they'd entered into agreements with enterprise clients, large companies, And these announcements suggested that GetSwift had a solid contractual arrangement with these various enterprise clients when the reality was that the relationship had not progressed beyond a trial phase. And clearly, the benefits arising from those agreements were not secure, quantifiable, or measurable. The second allegation related to continuous disclosure breaches, but this was a failure by GetSwift to inform the market of material changes, namely the termination of a number of agreements that had been subject to announcement, and also decisions by various enterprise clients that they weren't going to be proceeding to the trial through beyond the trial period. So there was a over, I guess, selling the commercial relationships that had been entered into and a failure to tell the market when those commercial relationships effectively collapsed. And there's an observation there by Justice Lee in circumstances where GetSwift had a limited operating history and had incurred historic net losses and where publicly available information about recent operations and performance was lacking. An important issue is whether GetSwift's failure to disclose this information would have had a significant influence on whether an investor would acquire or dispose of GetSwift shares. So effectively, there was very little information on which investors could make decisions. The company had not been trading very long. It had not made any money. There was not much publicly available information, with the exception of these ASX announcements. So the conclusion was that investors were relying heavily on these ASX announcements to make decisions about whether to buy or sell their shares. So the findings made by Justice Lee in the liability case was firstly GetSwift liable for 22 contraventions of continuous disclosure obligations and 40 contraventions of misleading deceptive conduct provisions effectively. Hunter, the Chief Executive Officer, was not only concerned in 16 of the 22 continuous disclosure breaches and 29 of the 40 misleading deceptive breaches, and that he also failed to exercise his powers to discharge his duties as a director in breach of Section 180, subsection 1 of the Corporations Act. Also, findings that McDonald was not only concerned in 20 of the 22 continuous disclosure breaches, 33 of the 40 misleading deceptive breaches, and also failed to exercise his duties as a director. And finally, Eagle was only concerned in only 3 of the 22 continuous disclosure breaches, none of the misleading deceptive breaches, and he also failed to exercise his duties as a director. A fairly comprehensive success for ASIC on its case. Now, the closing comments at about page 871 of that judgment, where Justice Lee makes this observation. He says he wants to make two final observations about the case. First is that the vast scope and highly repetitive nature of the ASIC case has placed significant demands on the court in resolving this case in a timely manner. So effectively, he's noting that ASIC ran this very, very big case, bigger than Ben-Hur, highly repetitive. And the question there is whether, was that really necessary to run such a big case? And he says there where the misleading deceptive conduct part of the case, which seemed to him to be an exercise in supererogation, which I think means quite duplicitous in the allegations made. And then secondly, he said, despite his scepticism as to whether the case of this scope was necessary in order to achieve the relevant regulatory purpose, those acting on ASIC's instructions did a great job. So he's effectively saying, well, ASIC made a decision to run this big, big case, but I'm not levelling any criticism over the lawyers and barristers in the room who conducted the case with great efficiency, courtesy, and professionalism. So he's making those two final points. Now, I think that occurred, I guess, kind of in the middle of the proceedings effectively was an application by GetSwift to enter into a scheme of arrangement to re-domicile its business to Canada. And this would result in them being delisted from the ASX and listed on the Canadian Stock Exchange, the NEO Exchange. And so it sought orders from the federal court under sections 411(1) and 1319 of the Corporations Act to approve a scheme of arrangement allowing it to undertake these steps. And in order to get over the objections from various groups, including ASIC and the Federal Treasurer, the parties provided undertakings and deed polls to the court to ensure that the judgment the judgment arising from the ASIC case, was something that still could be enforced if the scheme of arrangement was implemented. So effectively, the movement of the economic entity to Canada should not impact either ASIC's ability to recover penalties or the ability of a class action to recover damages. And that was a condition on which Justice Farrell permitted the scheme of arrangement to proceed. Now, the interesting thing here is what Lee said about this particular decision by Farrell to allow this. And this is in the liability judgment. He says, in an unusual development during the pendency of regulatory proceedings and around the same time the evidence concluded in the liability phase of the case before me, so the scheme arrangement's being approved in the middle of the ASIC case. GetSwift entered into an implementation deed in relation to proposed scheme arrangement, the intended purpose of which was to re-domicile GetSwift to Canada. So I guess the main point there, he's noting that it's a very unusual development to allow a company that's being taken to court by the regulator to re-domicile to another jurisdiction. Obviously, the big issue there is whether any judgments against it are going to be able to be enforced. Now, Justice Lee makes this observation about GetSwift in his judgment about how funds were moved out of the country without any explanation. And he refers to the Australian Financial Review article, GetSwift Too Fast for Its Own Good, back in January 2018, failed to update the market about losing materially significant contracts. And then it says that it transferred funds of $72 million to a bank account held by GetSwift Incorporated in the US, and then following the commencement of the ASIC investigation, another amount of $8.5 million was transferred to offshore bank accounts held by GetSwift Inc., bringing the total funds transferred overseas to $80 million. And as Justice Lee points out, there was no evidence explaining why those steps were taken. And then again at paragraph 4 of the penalty judgment, Justice Lee's commenting on the scheme of arrangement. And again, he seems quite critical of what occurred. And here he says, more remarkably, well after the balloon had gone up, the share price had plummeted, a class action had been started, and around the same time that evidence concluded in the liability phase of the ASIC regulatory case before him, GetSwift sought to re-domicile in Canada. GetSwift convinced another judge of this court to allow it to do so, partly on the basis of undertaking from GetSwift Technologies Limited that it would not take any steps to wind up GetSwift, would indemnify GetSwift in relation to penalties imposed in the case or in relation to adverse judgment in the class action. ASIC did not preemptively make an application to Justice Lee to restrain that from occurring. This highly unusual course was proposed during the pendency of the regulatory proceedings, although it did oppose this scheme of arrangement before Justice Farrell. So he's just saying this is quite remarkable that this is sought to be done right at the time when there's so much activity going on by ASIC and a class action. And then he notes that the undertakings which various parties provided to the court in Farrell's case were not worth the paper they were written on. GetSwift resolved in July 2022, contrary to its undertakings, to put GetSwift into voluntary liquidation. That resulted in no returns to the class action brought by the shareholders, so that's Webb and GetSwift, and also the amounts that will be awarded to ASIC for the breaches of the legislation against GetSwift won't be able to be enforced. And there he notes Justice Murphy's comments, who was the judge presiding over the class action. And he said GetSwift's own misconduct has now brought it to its knees and that its actions represented a scandalous episode of corporate misconduct. So he's agreeing with Justice Murphy's comments. And the fundamental question here is, why did the federal court agree to the scheme of arrangement? It seems like an error. I'll come back to that point later on. Now, the consideration of the appropriate penalty was discussed by Justice Lee in his decision, and he went through 8 factors. The first, that general deterrence is still important, even though the country has gone into liquidation. Given GetSwift's size, its financial position, the extent of the contraventions, and the significant role of the leading executives in the conduct, means that it's important to proceed with a large penalty to show the court's disapproval of that conduct. He said that the proposed penalty takes into account the seriousness of the contraventions, and they were very serious contraventions, very blatant. It was also conduct that occurred over a long period of time. Often continuous disclosure breaches may be quite short. Here there was conduct that continued for over 20 months, so it was very long for continuous disclosure breaches. The wrongdoing was insidious, tricky, and omitted information which would not have been discoverable upon inquiry by a third party. So it was misleading conduct which was successful in encouraging people to invest, and there was really no way of them fact checking the information provided. Also, the contravening conduct had real life consequences for the investing public, materially prejudiced the interests of GetSwift members. So people lost money as a result of these misrepresentations, and a significant amount of money. The contraventions were the result of a plan and constituted deliberate conduct by the company as part of a public relations driven approach to corporate disclosure executed by the company's most senior officers. So it doesn't really get much worse than that. It's a premeditated attempt by the senior managers to make lots of money. GetSwift did not cooperate with ASIC, putting ASIC to proof on virtually all matters, however obvious, at great expense to the public. And this is partly ASIC's fault. If ASIC hadn't run such a huge, bigger than Ben-Hur case, then it wouldn't have cost the public so much to run the litigation. And finally, there was no evidence of contrition or remorse by any of the company's senior officers. Both Hunter and McDonald didn't show up for the penalty hearing, and as Lee notes, indeed the evidence points to the opposite direction, that there's absolutely no contrition or remorse. Now, he does describe each of the different individuals. Hunter displayed a management style that owed little to the influence of Dale Carnegie. So I guess Dale Carnegie was a management guru, and I think his most famous work was How to Win Friends and Influence People. So obviously, Mr. Hunter wasn't too keen on winning friends and influencing people positively. He also noted that he was demanding, forceful, regularly brusque to the point of rudeness. He was not only a bully, but also someone who had laser-like focus on making money for himself and Mr. McDonald. If that involved breaking the law and the law regulating financial markets or exposing GetSwift to third-party liability, that was a little concern to him. That's pretty blunt assessment of Mr. Hunter's character. Mr. McDonald, although apparently in the thrall of Mr. Hunter, was no mere cat's paw. I like the terms and the turn of phrase by Justice Lee in his judgment. There's plenty of this throughout the whole judgment, so it's well worth reading the penalty decision. As he has explained, he was an active and eager participant. This conduct plainly enough demonstrates that Mr. McDonald had little understanding or regard for his legal obligations as director when they get in the way of pursuing a strategy to make money. Now, the comments of Mr. Eagle were less critical. He did actually engage with the court in the penalty hearing, but he did conclude that his strong impression of Mr. Eagle was that he didn't have a good understanding of the damage which his conduct had caused. He didn't appreciate the seriousness of the contraventions. And as you see in the second sentence, Mr. Eagle appeared fixated on the harm that had been inflicted upon himself and his professional standing, but not necessarily the harm that had been occasioned to others, shareholders, and the broader public. Now, the final orders made by the judge in this case, GetSwift, which was in liquidation, was ordered to make pay a penalty of $15 million for the continuous disclosure breaches. Hunter was ordered to pay $2 million for the various breaches and disqualified for 15 years. Not too sure why it wouldn't be a life ban for Mr. Hunter. I think that seemed appropriate. Mr. McDonald was ordered to pay a pecuniary penalty of $1 million and banned for 12 years. And Mr. Eagle, and this is significantly less, was ordered to pay $75,000 and disqualified for a period of 2 years. Now, the one thing I'll add in here is some further comments about the scheme of arrangement. And Justice Lee keeps going back to this. It just sounds like he's really surprised that the scheme of arrangement was agreed to. And I think that's, quite a remarkable thing that you'd agree to a scheme of arrangement in this situation. But he says here, I've determined that it's a matter for the judge, Justice Farrell, in separate proceedings, and who received and acted upon the undertaking to determine what, if anything, should happen next, including whether the matter should be referred to the principal registrar of the court for contempt proceedings to be instigated. Now, it seems to me that the court's probably not going to move of its own volition. Rather, somebody has to approach it and seek some orders for contempt. Probably ASIC should really go to the court and seek some orders there. Obviously, the judge isn't going to just pursue that issue herself. He also says it became apparent at the time of the appointment the liquidators were not aware of the undertaking given the court, but the liquidators did become aware of the undertaking on a particular date. They did not inform the court of the breach of the undertaking until ASIC filed its submissions on penalty and other relief. Now, that's a big concern. Why weren't the liquidators immediately telling the court of the breach of the undertaking? Clearly, if they'd done that immediately, maybe there might have been some prospect of stopping the process. But it seems like clearly a very relevant thing for liquidators to be, as officers of the court, to be telling the court that they're aware of a breach of an undertaking given to the court, not to place a company in liquidation. So just a bit of commentary. This is very serious conduct, and it's good that ASIC pursued it, but I think it really needs to consider the way it runs cases. Like, if you run bigger than Ben Hur cases, they're going to take you a lot of time, a lot of money, and a lot of negative things are going to occur in the meantime. Better to run a more targeted case. The continuous disclosure breaches were very serious. They caused a lot of detriment. And that was probably all they needed to pursue in this particular case. They could have easily just ignored all the separate misleading, deceptive conduct allegations. They didn't really add a lot to the regulatory purpose which ASIC was seeking to achieve. And this is an area where I think the ACCC are very good in terms of running compact, targeted cases usually, and not throwing the kitchen sink at people. You can run cases much more quickly if you do that. So there was a lot of criticism in the ASIC case, primarily the size and vast nature of it and whether it was somewhat repetitive. The decision to allow the scheme arrangement was quite a remarkable decision. I don't quite understand why that decision was made. It seemed pretty apparent that there was going to be some funny business undertaken by the company, and the undertakings were never going to be worth the paper they were written on. And I think the judge there placed too much weight on the submissions by GetSwift and the independent expert, and placed too little weight on the genuine concerns that ASIC had. And the Federal Treasurer also expressed some concerns about this matter. So I think that was a mistake. Clearly, there should be steps taken now to pursue contempt proceedings against any persons involved in providing these undertakings to the court, if possible. I don't think we'll be seeing Mr. Hunter or Mr. McDonald back on these shores anytime soon. But clearly, if any other individuals were involved in providing undertakings to the court that have proven to be false, then some action should be taken in relation to that. And it'd be interesting to see if the court takes the hint from Justice Lee that those issues should be genuinely pursued. So that's all I had. Hopefully that's been helpful. Clearly the liability judgment is a very, very big judgment, and I think too many people are going to be reading through that. But I think I've extracted what's most important. The scheme of arrangements is a big aspect of this, and I think the federal court would be probably, hopefully, more cautious to allow these types of scheme of arrangements in the context of a regulatory litigation and class actions, given the worthless nature of the undertakings. And I thought the penalty judgments were worth reading, not only for the clear way that Justice Lee sets out the issues, but also the various turns of phrase. It's quite an entertaining judgment to read. So if you have any questions about this, feel free to give me a call or send me an email. Bye bye.